that have been asked or not?
No, I think they just come straight through to us.
Okay, that's fine.
Okay, people are joining now.
Joe? No. Presumably only you can still hear me and see me, is that right? Okay, we've got up to a good number now, so I think we're going to start. So good afternoon, and thank you for attending this webinar entitled Changing the Terms of Trusts. As I only have 30 minutes today, I will be limiting my talk to the approval of arrangements under the Variation of Trusts Act 1958. However, there may be scope for further webinars on other means of changing the terms of trusts using dispositive powers under the rule in Saunders and Vautier, applications under the inherent jurisdiction, or under other enabling statutes, both onshore and offshore. So if any of those topics would be of interest to you, please do let me know or contact Chambers, and we'll see if there's room for doing that during the remainder of the so-called lockdown period. Finally, before I start, there's a 3-line whip from the gods of the marketing committee that I'm to inform you of 2 matters. First, that there's a question and answer function which you can use to submit questions, although given the time frame, it may be that there isn't time to answer them at the end, but we may be able to deal with them in subsequent webinars. Secondly, to let you know that this webinar is being recorded and should be available on the Chamber's website, I assume later today, but in due course anyway. Joe, if we could just move to the first slide. Joe, can we just move to the first slide? Thank you. So the court's jurisdiction under the Act is entirely statutory, following the decision in Chapman and Chapman. So the starting point is the Act itself. And in most cases, practitioners need only have regard to one section of the Act, and in most cases, indeed, just one subsection of the Act, that being Section 1, unless you're involved in Northern Ireland cases. And the subsection that's relevant is subsection 1 to section 1, which is on the slide on the screen. However, as you'll see, there's quite a lot packed into that section, and sometimes some points of it are overlooked and people don't pay regard to its precise terms. So I'm going to spend some time, first of all, summarising the statutory jurisdiction with reference to this subsection in particular. And then I'm going to look at some frequently asked questions in practice so as to look at some of the practical elements of the application of this jurisdiction. So turning to the Act, the first point to note is that the Act limits the court's jurisdiction to approving arrangements on behalf of certain classes of beneficiary, firstly minors or children, and minors or children will come within section 1(1)(a) of the Act if they have a vested or contingent interest under the trusts, and that does include interest as a beneficiary of a discretionary trust. Secondly, persons lacking mental capacity. It hasn't made it onto this slide, but section 1, subsection 3 of the Act provides that it's for the Court of Protection to determine whether a proposed arrangement will be for the benefit of a person lacking capacity. It may, however, be possible to avoid the need for court assistance altogether, or to reduce the expense of a 2-stage exercise where the other beneficiaries are ascertained in sui juris, and depending on whether there's a lasting power of attorney or an enduring power of attorney in place. It's also worth noting that recently the court has confirmed what has been thought and known for some time, which is that if you have someone who lacks capacity, possibly because of an injury at birth, the High Court still has jurisdiction under section 1(1)(a) on the basis that they're a minor, so long as they're still a minor, without needing to have regard to the Court of Protection, so that you can avoid some of the difficulties that might involve. Next, in subsection C, future interests. Sorry, subsection B, future interests. And this section of the Act is directed at trusts in favour of persons who will at a future date or on a future event satisfy a particular description or come within a particular class. An example is a life interest in favour of the widow of a life tenant, the event therefore being whoever is married to the life tenant at the point of death. However, the proviso in that subsection, which is sometimes overlooked, is that any person who would satisfy the relevant description or come within the relevant class if it was assumed that the date or event of relevance had happened at the date of the application to the court is excluded. Therefore, in the example above, or that I've just given, the court would not have jurisdiction to consent to an arrangement on behalf of the life tenant's present wife. Next, subsection 3, unborn persons, unborn beneficiaries. This class is not defined by reference to any prospective interest or right in the trusts, and therefore some of the difficult questions which arise in respect of beneficiaries lacking capacity, beneficiaries with future interests do not arise, but some other interests in practice do come up, and I'll hope to deal with a few of those in the frequently asked questions section. Finally, in subsection D, protective trusts, which are kind of dealt with in a different way to the other classes. The court has power to give consent on behalf of any person with a discretionary interest under a protective trust. And it's important to remember that this class, as well as including unborn and unascertained beneficiaries, includes ascertained capacitous adults. So having gone through that list, the one thing that you really have to emphasize is that the Act doesn't give the court power to approve an arrangement on behalf of any person who falls outside these classes of beneficiaries. So save in the case of protective trust, beneficiaries who are both of full age and capacity are entitled to decide for themselves whether the arrangement should be given effect or not. And of course, that can scupper the entire exercise. And that's so regardless of how difficult or impractical it would be to obtain consent. And that's one of the primary differences that you'll find in terms of the Act as it's in force in England and Wales compared to the enactments which are broadly in line with the English statute in offshore jurisdictions. Sometimes, though, it may be possible to bypass the need for an adult beneficiary's consent. First, for example, if there are ultimate trusts in favour of a large class of beneficiaries who will only take in the event of the failure of beneficiaries interested under prior trusts, the court might be prepared to approve the variation on behalf of the minors, unborns and unascertained beneficiaries and let the trustees take the risk of a claim from the adult beneficiaries. Alternatively, it may be possible to exercise the trustees' powers to exclude that class of beneficiaries from benefit, even if those interests are expressly going to be reinstated after the variation is approved. This quite punchy practice was endorsed recently by Mr. Justice Warren in the case of A and B in 2016, but I'd suggest that it's only undertaken with caution and with respect to the most remote interests only. The next point to note with respect to the Act, the next point to note with respect to the Act is that it's expressly exercisable in respect of almost all trusts. The Act applies to trusts arising under any will, including the trust of administration, settlement, any settlement or any other disposition. Moreover, the jurisdiction is not confined to express trusts, but extends to implied, resulting, and constructive trusts. The Act may also apply to trusts governed by a foreign law. This was expressly held to be the case in a couple of cases in the 1960s, but it's unclear whether this remains so in light of the Hague Convention. In any event, it seems that there will be some circumstances where the court will apply the Act to foreign law trusts, given that it did so, I think, His Honour Judge Hodge in the case of C&C in 2015. In any event, so far as foreign elements are concerned, it is worth remembering that the court clearly has jurisdiction under the Act to approve the complete revocation of an English law trust and to transfer the trust property to foreign trustees to be held on trust governed by a foreign law. And indeed, it will generally do so if a substantial foreign connection is established, it's satisfied that the court effectively to which it's transferring it will be able to enforce the trust, and that the new trustees have suitable experience. Finally, in terms of the scope of the jurisdiction with reference to the Act, I draw your attention to the fact that the statutory description of the arrangements which the court can approve is very wide indeed. There is, however, a restriction developed in the case law, sometimes referred to as the substratum limitation, and it comes from a judgment of Sir Robert McGarry, no less, in Reball's settlement trust in 1968, where it was held that if an arrangement changes the whole substratum of the trust, then it may be that it cannot be regarded as merely varying the trust. Putting aside the question of what exactly is meant by substratum, I think it's right that some doubt has been placed on this restriction, and rightly so, particularly in offshore jurisdictions and in the Channel Islands, which have enacted similar legislation. But this restriction on the application of the Act has nevertheless proved a useful means of avoiding UK capital gains tax, on the basis that any arrangement approved by the court cannot, by definition, be a resettlement. Okay, Joe, if we could just move to the next slide. So turning from the scope of the jurisdiction as provided in the Act to the test which is set out in the Act as well, as many of you will be aware, it's expressly stated that the court cannot approve an arrangement on behalf of the classes of beneficiaries we've discussed unless carrying out the arrangement is for the benefit of those beneficiaries. Now, financial benefit is usually required, and this is usually provided by the terms of the arrangement alone. But it can also be provided by a policy of insurance or a personal covenant that's secured, unsecured from a member of the family or otherwise, as long as there's evidence of their ability to pay it. Non-financial benefit may also be sufficient on its own, or at least relevant in the balance as well. And the classic example is the postponement of a minor beneficiary's interest to prevent them from receiving too much too soon. That can be seen in a number of cases. For example, I think the T settlement trust was the Lord Denning decision, which is a good example, and also Wright and Gator more recently. Another example of the non-financial benefit, or social or moral benefit as it's sometimes called, is the benefit in discharging a beneficiary's legal or moral obligation to another beneficiary or other person. But remember that minor and unborn beneficiaries will rarely have those obligations to financially independent adults. It's important to remember that the court's jurisdiction is discretionary, and so the court isn't bound to approve an arrangement merely because it considers it to be marginally beneficial to the beneficiaries with which it's concerned. The court will therefore undertake what has been described in Griersons Will Trust, which I think is on the slide, yes it is, as they'll undertake a practical and business-like consideration of the arrangement, including the total amounts of the advantages which the various parties obtain in their bargaining strength. In other words, the court will ask whether the persons, if the persons on whose behalf consent is to be given were themselves competent and reasonable, whether the bargain is one that they would enter into. Now, it's interesting that really that language fits quite easily with old school or old style variations where you're partitioning a fund, but don't really fit with the majority of modern type variations where you're perhaps extending a perpetuity period, but yet nevertheless that has remained the test that people look to. However, there has been some attempt to objectify the assessment, particularly in respect of non-financial benefit, where caution is obviously required to prevent the process simply becoming a reflection of the judge's individual perceptions and preferences, if indeed that's possible, because inevitably it does become that. But Mr. Justice Norris attempted to objectify the assessment and put forward a potential test for doing so in the case of Wright and Gator, which is on the slides. I would say that I'd recommend as well, if for anybody who's watching this webinar and doesn't do a lot of VTA applications or otherwise feels a bit rusty in this area, Wright and Gator is a really good judgment to get to grips with the case law, and it references a lot of the leading cases, which are also themselves quite good reading because they're 1960s cases and therefore very short and often to the point from very eminent judges. Joe, if we could just move to the next slide. Joe, could we just move to the next slide, please? No, the slide before that, please. Okay. So having summarised the jurisdiction with reference to the Act, the next logical step is to set out some of the circumstances in which it's employed. Obviously, I can't provide a comprehensive list of all the types of applications that one could make because they're made in manifold circumstances. However, the following are particularly common uses of the jurisdiction. So firstly, arrangements to avoid or mitigate the incidence of taxation. A common example is to postpone an occasion of absolute entitlement for capital gains tax purposes, often utilising the non-financial benefit that we've discussed. Variations are also made here and in foreign law jurisdictions to avoid unforeseen changes in the taxation regimes to which the beneficiaries are subject wherever they are in the world. Secondly, arrangements to create a new perpetuity or accumulation period. As I've said, in my experience, this is now the most common type of arrangement, and it's typically used to obtain a number of benefits, not least capital gains tax benefits, in dynastic settlements. And reported examples, if you're interested in looking at them, can be found in Wyndham and Egremont, Alfrey and Pemberton and Pemberton. Third, arrangements to postpone the vesting of income or capital in a young person. We've discussed that a little bit already, and that's still quite a common use of the jurisdiction, particularly in my experience in deed of variation type variations to achieve a deed of variation where there's a minor. Fourth, arrangements to partition a fund. As I've said, that was traditionally the main use of this jurisdiction. It still occurs, but less so. Usually what the court will be interested in is valuing the minor or unborn beneficiary's interest so as to partition the fund, and for that purpose you'll need actuarial valuations. But the court will be very cautious in making sure that it gives maybe a little bit more than the actual aerial valuation so that the minor is not shortchanged. Next, arrangements to eliminate the interests of unborn beneficiaries. It's necessary to provide benefit to all of these people, and obviously if you want to separate them from the fund for any given reason, usually it's necessary to give them a fund themselves in some way, including using risk insurance or a covenant for their benefit. Finally, arrangements to facilitate the administration of trusts. Here we're kind of talking really about incidental variations to the other type of variation, because you may use section 57 for these things otherwise. Examples include allowing non-resident trustees to be appointed, also widening the investment powers within the trust. Sometimes it's worth knowing, though, that the court is reluctant to provide wider investment powers than those now permitted by statutes. Not always, sometimes it's perfectly willing to do so. Of course, that can cause a bit of a problem because most internal precedents in private client departments include provisions which are wider than the statutory provisions. So there is some caution required when you're doing that. However, even if the court is taking that restricted approach, it will usually still be willing to provide wide powers ancillary to the modern statutory powers, such as investment management and nominees. Another thing which is sometimes done to facilitate administration nowadays is varying the applicable definition of issue, children, descendants, and spouse to include, for example, adopted illegitimate children, adopted and illegitimate children, same-sex and same-sex spouses. These variations can be quite difficult to justify on their own, but it might be that they're desirable in the grand scheme of things. An example where it happened was in Pemberton and Pemberton, the extension of perpetuity period case, which I've referenced. Also, other considerations that you have to take into account is the court's approach now to the Human Rights Act and trusts, and whether you're saving the trust from that kind of construction issue down the line. And I think that's something that my colleague Eliza Eagling will be talking about on Monday. So Joe, if we could move to the next slide. So finally, having gone through the jurisdiction, I am now going to just go through some frequently asked questions as a means of talking about some of the practical application of the jurisdiction. So firstly, will the court really be concerned with unborn beneficiaries with very remote interests? And given the clear terms of the Act, this is actually a surprisingly common question, but in short, the answer is yes. The variation must be beneficial to each and every potential unborn beneficiary, however remote their interest. Of course, that isn't to say that there must be direct financial benefit, or that the variation must be beneficial in every possible circumstance for the remainder of the trusts. And it will usually be possible to find or provide that benefit, and it's a very rare occasion when one can't do that. However, what I would say is that perhaps for understandable reasons, unborn beneficiaries with remote interests are often an afterthought in variation applications. And in my experience, this can cause problems as the application progresses, particularly modern style variations, which seek to extend the settlement's perpetuity period. Because in those type of variations, unborn beneficiaries may often have complex potential interests between the date of the application and the end of the current perpetuity period, which can make it difficult if the scope of the variation across lots of various sub-funds, for example, with very different provisions, is part of the arrangement. Or, for example, if early on a power has been exercised to make the arrangement obviously more beneficial to a more obvious class of beneficiaries, such as a child, without thinking about the potential negative consequences, at least prima facie, that will have on the unborns who need to be represented and approved. Another often overlooked point, which is why you should look at this from the outset in terms of unborn beneficiaries with extension of perpetuity applications, this is that the unborn beneficiaries who will be born after the current perpetuity period, if that's possible because the perpetuity period end of the current perpetuity period isn't too far away, will not be part of the class of unborn beneficiaries that the court is concerned with. They simply are not beneficiaries of the trust. And that is an often overlooked point. And therefore, sometimes it's very easy to say, oh, the unborns are fine because they'll obviously just have longer to benefit. But actually, sometimes the consequences of the extension is that some unborns who would be born before the end of the current perpetuity period would, in certain remote circumstances, obtain absolute interests in large funds and are now going to have to share that with possibly their siblings, cousins, whoever it may be, or indeed not benefit themselves because they die too young, and that passes on. So that can be problematic for the class that is actually being represented. So it is, as I say, important that you think about unborns from the outset. Obviously, that's true of all beneficiaries. And another point I'd just make in passing about that is that when you assess the benefit to unborns and to any class of beneficiary, it is important to consider the current and proposed trusts, both in isolation and in context. It's very easy to get bogged down in just what the terms of the trust are, but as Lady Hale said in second out, and I think that applies equally in BTAs, context is everything. And by context, I mean in particular the nature of the trust and their underlying purpose, the nature and value of the trust fund, the powers, and this is very important, the powers of the trustees and any indication of how they might be exercised, and the fiscal landscape generally. So moving on to the second frequently asked question that I've put forward here. Will the hearing be in private and will any judgment be anonymized? This is obviously sometimes a concern for clients. Until relatively recently, the practice of the Chancery Division, as I'm going to insist on still calling it, was for applications under the Act to be heard in private. But that practice no longer applies following the decision in V and T and A and MN and OP, save in respect of children and in exceptional circumstances. There are, however, some practical considerations or tactics which one might use to reduce the risk of publicity, even though it's in open court. The first is that masters now generally hear applications under the Act rather than judges, as it used to be, rather than High Court judges, as it used to be. This makes it much easier in general to fly below the radar because, in my experience, journalists don't tend to spend much time loitering around the master's corridor, or at least not the physical corridor with which we were all familiar until recently. But there is anecdotal evidence to suggest that journalists are attending more and more virtual hearings while the social distancing measures are in place. Another thing to consider is the title to the claim form before you issue it. One thing which will obviously prick the interest of the Daily Mail is the name of an aristocrat, celebrity, or politician. That's the stuff that they love. So you could name the claimant as Marmaduke Chuffnell rather than Marmaduke Chuffnell, 5th Baron Chuffy Chuffnell. And then if necessary, you can produce a draft order for the hearing, which includes the barony or whatever it may be. Another thing you might want to think about is the order in which the defendants are listed. Cause lists rarely name the 20th defendant. So the journalist will never know that the 8th defendant to the case of Bassington and Fungi Phipps is one Roderick Spode, Vladimir Putin, or whatever it may be. However, you should be aware that the court will not be impressed if the claim is made or the application is structured in an entirely inappropriate way. And if that annoys him sufficiently, he may well write a judgment about that inappropriate tactic, thereby defeating the object of the exercise entirely. So you'd have to really want to avoid publicity to perhaps do that. Finally, you might want to avoid trying to suggest that the application raises a novel point, again, because that might tempt the master to write a judgment. The third question about costs. So how will the cost of the application be borne and assessed? Well, of course, the incidence of the costs is a matter for negotiation between the parties and between counsel. It will, of course, be relevant to the consideration of benefit that the costs are or are not to be borne from a fund in which the minor, unborn, or unascertained beneficiary is interested. However, you should bear in mind that there isn't complete freedom in all cases. For example, if the court is being asked to approve a post-death variation, the object of the exercise is likely to be defeated if there is extraneous consideration. So to my mind, it would be risky for the surviving spouse to bear the costs of a variation, providing him or her with a short-term life interest where he or she does not otherwise benefit from the estate. There may, of course, be ways around achieving around that problem by using the 1975 Act in particular, but that is out with the scope of this talk. The other thing to know is that usually, while the court will usually approve the arrangement, including the cost agreement that's been reached by the parties, that isn't necessarily the case, of course. And if the application is unsuccessful, firstly, the claimant may be ordered to bear the costs. And equally, even a successful applicant may be ordered to bear the costs if he or she was the author of the arrangement and the only person with liquid funds. And you can see a judgment on that point at the end of the case of Pemberton and Pemberton, which I've already referenced. Finally, in terms of costs, it's important to remember that it's no longer the case that the court will necessarily permit costs to be paid from a fund in which the minor, unborn, or unascertained beneficiary or beneficiaries are interested to be agreed rather than assessed. The Chancery Guide now provides that where parties are represented by the same solicitors and counsel from the same chambers, the court is as they almost inevitably are, the court is unlikely to assess costs summarily or to dispense with an assessment of costs on the basis that they've been agreed. So it's important to remember that. However, there are some things that you can do to make it more likely that the court will give you the old style order for agreement. In my experience, the court will be often willing to make the old style order if there are adult parties or representatives in a position to scrutinise the cost bill So there may often be a benefit in a family member rather than a solicitor acting as litigation friend, for example. Also, it may be that the trusts are such that the adult beneficiaries will really be the ones who have to bear the cost order that's been agreed. And so that they will have to scrutinise the cost bills. So again, that might be another basis from which you can ask the court to make an order that the cost be subject to detailed assessment if not agreed. As with the other points I've already discussed about unborn beneficiaries and generally, the takeaway from that really is that when you look at it, making a variation application, it is important to think about all these things at the very outset. Okay, so I've reached the end, I think, of the 30-minute slot that I've got. I did receive one question by email just before this webinar took place, so I will try to answer that. And the question was, are there any circumstances when a deed of variation set up on a will can be varied? And the answer to that, well, firstly, you can, and very often one does, use the jurisdiction to enable a deed of variation to be entered into under Section 142 of the Inheritance Tax Act. In terms of variation of the terms set up by the deed of variation, that rather depends on the terms which are set up, but in theory, yes. As I've said, the Act applies to almost any, to trusts under any disposition. Of course, a deed of variation is merely a disposition in the real world, being made by the beneficiaries who would otherwise have received the property. So assuming that trusts are created by that variation, then yes, you can vary it. Also, the other thing to bear in mind, if this is really what's in issue rather than a proper variation, is that you can potentially rectify that instrument. They're all the questions that I've received, fortunately, because we're out of time. So I think that draws matters to a close. And I'll say just thank you for attending this webinar, and that I hope to see many of you soon when we return to normality. Okay, thank you. Good day.